Good afternoon, everybody, and thank you for joining us for the 6th webinar in Conn Maciel Carey's 2017 OSHA webinar series. Today we're going to be talking about formal letters of interpretation and other forms of OSHA guidance, as well as the regulatory variance process available under the OSHA scheme. In particular, we're talking about this because we view these two areas, letters of interpretation and variances, as presenting a new regulatory strategy as we transition from the Obama-era OSHA to a Trump-era OSHA. These may become more available to employers and something that may be looked at as an offensive or proactive tool that employers can take advantage of in a way that they have not been able to for at least the previous 8 years, and really maybe for quite some time before that because of changes in the law. Let me first do a couple introductions and then we'll dive right in. I recognize a lot of the names here of folks who have dialed in, so hopefully you recognize me as well, but for those that don't know me, the one of the faceless voices that you'll hear today talking about this issue is Eric Conn. That's me. I'm one of the founding partners and chair of the OSHA Workplace Safety Practice Group at Conn Maciel Carey, where my practice focuses essentially exclusively on workplace safety and health, regulatory and legal matters. I work with my clients, employers, to navigate through inspections, investigations, and all manners of enforcement actions involving primarily OSHA and the state OSH programs, but also the U.S. Chemical Safety and Hazard Investigation Board, the CSB, MSHA, EPA, and other agencies that tend to get into the mix on workplace safety and health matters. We handle all aspects of OSHA litigation, from criminal prosecution to appeals of OSHA citations. We help employers develop programs, audit programs, and we speak and write regularly on safety and health issues. I'm going to let my partner, Kate McMahon, introduce herself real quick, and then we'll dive into our topic.
Good afternoon, everyone. Nice to be with you all again and with Eric to talk to you about variances and letters of interpretation, what we know, what we think we might expect over the next few years, the opportunities that might present themselves, and how to strategically take advantage of those opportunities. I have spent, more years than I will admit working in this field. My areas of specialty are sort of run the range of OSHA matters. My, dear and near to my heart are OSHA chemical rulemakings. I have spent a lot of years working with the agency on behalf of clients in this area, and I'm hopeful that we will have another few years here where we might make some real headway in that area. So with that introduction, why don't we begin our topic today?
All right, so here's generally speaking what we're going to cover. What are OSHA letters of interpretation? What are regulatory variances and all the little subheaders and nuances below that? We'll talk about the processes, the timing, strategies, and potential pitfalls of pursuing these two regulatory opportunities. And then we're going to talk a little bit at the very end about some specific substantive areas that I think are ripe for new interpretations, reinterpretations, or areas where a variance may be needed and appropriate, and sort of to give you some ideas as you think about if this is a tool that is appropriate for your industry, for your company, or for you, then what are some areas substantively that it might make sense to look at that area. So let's talk first about an overview of OSHA's letters of interpretation. Letters of interpretation are essentially OSHA's official response to a written inquiry about compliance with the agency's requirements. So OSHA requirements, the actual things that you are required or prohibited from doing in your workplace, are set by statute, they're set by standards, and they're set by regulations. A letter of interpretation from OSHA is a tool that OSHA uses to clarify those requirements, to clarify what the language of a standard means, to provide context. And often you'll see that a regulation relates to either very specifically to a piece of tool or an activity or a work activity, but sometimes it's general and it applies across many industries, to many different pieces of machinery, to many different work practices. So the language of the standard really can't give you all the context you need to understand how to comply or when you're not complying. And so a letter of interpretation fills in those blanks and tells you how that standard applies to a relevant set of facts as presented by some stakeholder. And these tools, these letters of interpretation, provide compliance guidance, and they explain how they apply to particular circumstances. There is a policy at OSHA that the agency shall respond 100% of the time to stakeholder or public requests for clarification about their standards. So anytime someone makes a written request to OSHA, there will be a response. That doesn't mean that there will be a formal letter of interpretation that you see on OSHA's website. It might be, if the email comes in informally by email, you might get an email response. But by and large, you're going to see some response from the agency addressing how your set of facts that you present, your inquiry, what is the interpretation and the agency's formal view of that particular issue. What is the legal effect of these letters of interpretation? I am not going to, those of you who are lawyers on the call and you see this header Chevron deference, don't hang up the phone just yet. I'm not going to get bogged down in a discussion about Chevron or our deference, which may be more appropriate in these circumstances. But I did want to just lay out this concept that, why are we so focused on interpretation letters? Why am I doing a webinar about this topic? It's because they're pretty powerful pieces of writing. The reality is that an agency interpreting its own standards, regulations, and statute are entitled to very significant deference and essentially substantial deference from a decision maker, an adjudicator, like an administrative law judge or the circuit courts or even the Supreme Court, provided that their interpretation is not arbitrary or capricious. And what that means is if OSHA offers an interpretation about one of its standards that is not the most logical interpretation, it's not the best interpretation, it is perhaps even a counterintuitive interpretation, perhaps it is a flip-flop from an earlier interpretation the agency has offered. A decision maker, like a judge, will follow and will give substantial deference to the agency about that interpretation unless it is arbitrary or capricious. So there may be better interpretations or more reasonable interpretations, but if it is essentially reasonable within the realm of reason, it is entitled to substantial deference. And that's why these interpretation letters are so important, because as you're litigating against OSHA, challenging a citation, or engaged in discussions with the agency about how to implement a compliant program at your workplace, their view, their formal interpretation of how that standard applies is given a tremendous amount of weight unless it is arbitrary or capricious, which is a really, really tough burden for employers to overcome. So that is to say that the legal effect of these otherwise informal letters that are produced by OSHA that don't go through notice and comment rulemaking, if they're not produced by Congress, they're not ordered by Congress, and they don't follow that Administrative Procedure Act requirements, are still really powerful unless they are arbitrary and capricious. So that's the Chevron hour deference concept behind an interpretation letter. There have been a couple of really interesting recent cases that shed light on the legal effect of these interpretation letters from OSHA. And one is a March 2015 decision by the Supreme Court in the mortgage bankers case. And that case was not about an OSHA interpretation, but it was about an interpretation of a regulation within the Department of Labor. And what the Supreme Court said in that mortgage bankers case was that agencies may reinterpret ambiguous rules without going through notice and comment rulemaking. So in other words, if the standard or regulation does not speak for itself plain as day, one of these opportunities for the agency to fill in the blanks about the context of a standard, that the agency may do that. And what this case was really about was if the agency has interpreted a standard or regulation in a certain way for however many years, they may flip-flop and issue a new interpretation, even if it is the opposite of a prior interpretation. And as long as it is not arbitrary or capricious, as long as it is generally reasonable, they may do that, and they may do that without going through APA notice and comment rulemaking. And that's significant because this means employers have come to accept that a rule requires one thing, and they've operated that way under that understanding for a long time. OSHA can change the regulatory requirement without going through notice and comment rulemaking as long as it is within reason, that interpretation. The Supreme Court in that mortgage banker's case did draw a distinction between interpretations that are legislative in nature versus those that are interpretive in nature. And an interpretation letter or guidance or some new interpretation from an agency that is legislative in nature, which means it is more substantive in terms of the scope of a standard. The big example that we saw where a court said, hey, this is legislative, not interpretive, was an interpretation that changed in a significant way the number of employers who are covered by a regulation. That is more legislative than interpretive because it's a rule that didn't apply to an entire group of industry stakeholders, and now it does. Or it changes thresholds in significant ways. That would be more legislative. But interpretive, again, sort of filling in those gaps as to what the language of a standard means rather than fundamentally changing the words of the standard. Those types of changes can be made by interpretation without notice and comment rulemaking, and they're entitled to significant deference in any context where you might find yourself in a dispute with the agency. That decision by the Supreme Court seemed to be narrowed a little bit by the D.C. Circuit. Of course, the Supreme Court could say the D.C. Circuit got it wrong, but in a recent case, the ag retailers case, the D.C. Circuit held that a particular OSHA interpretation about application of their process safety management standard was tantamount to a new standard. It appeared to the D.C. Circuit to be more legislative than interpretive, and therefore could not be made. This new interpretation could not be implemented by OSHA by simply issuing an interpretation letter, but instead notice and comment rulemaking was necessary to make that kind of change. That case may end up before the Supreme Court, and we may get some more clarity from the Supreme Court about what that means. But all of this discussion is to say interpretation letters are very important because they are the formal interpretation of the agency, and they have some binding effect in your perhaps adversarial engagements with OSHA about the meaning of their standards. They also have some level of permanence. It is not like a standard or a regulation or a piece of legislation that requires that same robust process, either bill making or rulemaking to undo it. They tend to have some permanence because of sort of the inertia of the bureaucracy that issues the interpretation. A letter of interpretation remains the agency's official interpretation unless or until it is archived, unless or until some new guidance is issued by the agency that contradicts it, or unless or until a judge vacates or overturns the interpretation through a legal challenge, either a legal challenge directly to the interpretation letter or a legal challenge in a specific substantive dispute with OSHA. For example, they issue a citation alleging a violation of their lockout-tagout standard, and they base the violation on an interpretation they've issued at some point in the past. The employer can present to the judge and to the review commission and to the federal circuit courts that, hey, this interpretation is arbitrary and capricious, or it's legislative in nature and it didn't go through rulemaking and it's an unlawful interpretation. A judge can decree that the interpretation is unlawful and force the agency to archive it. But unless those things happen, an interpretation remains the agency's formal interpretation. And you see some effort, right? I think we've seen some effort in the first few months of the Trump administration, more so than maybe any time in the past, an effort by the new administration to sort of undo some of the initiatives, the rulemaking, and policies of the prior administration. But generally speaking, even this administration is receptive to industry calls for repeal or change or amendment to interpretations and policies, but they're not really out there hunting for them. So unless you do something, unless your trade association or you as an individual employer or a group of employers take some proactive step to revisit an issue that you think OSHA has gotten wrong or has gone too far, those interpretations are likely to stay. And the reality is the Obama administration used the interpretation letter tool and the guidance tool in a way that we've really never seen in the past. And I think a lot of that was spurred on by things like the mortgage bankers' decision from the Supreme Court and sort of a recognition that the rulemaking process is cumbersome and costly and often ineffective. The Obama administration issued, it looks like, about 500, a little more than 500 new letters of interpretation during those 8 years, and that is by far the most that we have seen during an administration. So they did a lot of interpreting, and now there's a lot of Obama-era interpretations that are out there that employers and industry groups may feel go too far or are wrong. So unless you do something about it, go to the agency and seek a new interpretation, they will remain, the agency's formal interpretation that's entitled to deference.
Although I will pipe in for a few of those because there are a number of interpretation letters that we saw over the last number of years that were very helpful to our clients. So, even though they were issued under the Obama administration doesn't necessarily mean that they're bad things. We like a number of them, and we feel like we have really very good success in working with OSHA to show them why and how a particular portion of a regulation ought to be interpreted to render it, fair to the regulated community, something that is, workable for the regulated community, and we've had good success there.
Right, and that's a big part of what we'll talk about today is the process that you ought to follow to engage with the agency to achieve, we think, appropriate interpretations. So the last thing I'll say sort of on background about letters of interpretation is how they might be used in litigation, what is the evidentiary effect. And this goes hand in hand with what I was talking about before in terms of the deference the agency is entitled to. A letter of interpretation can be used offensively by an employer to defend itself if OSHA issues a citation alleging a violation of a specific standard, and there's an interpretation out there by the agency that says the way we were going about complying with that standard is appropriate. We can introduce that and say, look, this interpretation is entitled to deference, and it says what we were doing was appropriate. And you can use it also to support a variety of different defenses, like a lack of fair notice, that we believed what OSHA says is the proper way to interpret this standard, and if the standard requires something different than this, we lacked fair notice of what the standard required, and these letters of interpretation are very helpful in supporting those types of arguments. On the flip side of that, they are also used quite often and quite effectively by OSHA to prosecute a citation. They allege that you violated a standard that on its face you think you are complying with, but there is this interpretation letter that's out there that is the agency's formal interpretation of what the standard means. It hasn't been archived. It is not arbitrary or capricious. It is going to be evidence by OSHA to show that this is, in fact, what the standard means, and the employer had fair notice about what it meant. And as we said before, although these letters are the agency's formal interpretation, they are subject to challenge in the ways that we talked about before. So just a couple more points on interpretations, and we'll get then some background on variances, and then we'll get into process and pitfalls and things like that. I just wanted to say that when I talk about letters of interpretation, we're primarily talking about that situation where some stakeholder sends a letter or an email to OSHA, to the Department of Enforcement, to the DEP, saying, we need an interpretation about this regulation. But really, there's a lot of different forms of guidance out there from OSHA that all effectively have the same consequence, the same binding effect that we're talking about. There's compliance directives, frequently asked questions, non-mandatory appendices. The difference between these types of guidance and the letters of interpretation that we're talking about is that these types of guidance really can be issued by the agency sua sponte. They don't need a request from an industry stakeholder about the application of a standard to issue these. In fact, they issue these on their own, and they look different, but generally speaking, they have the same effect, as in they reflect the agency's formal interpretation. They can be introduced as evidence in hearings and challenges to citations. These things tend to come closer in time when a regulation is issued. FAQs in particular are often issued simultaneously or soon thereafter a new final rule. Likewise with non-mandatory appendices that are actually in the rule, in the CFR, although they are not the standard itself. They are used to interpret the standard, and compliance directives similarly interpret the standard, but also direct or instruct OSHA's enforcement staff how to enforce the standard, and that also provides guidance about what they mean. I'm going to turn it over to Kate in one moment to talk about background about variances, but before I do, I see a couple of questions here that are a real good question about how do letters of interpretation impact state OSH programs. Really, really good question. And the answer is it depends on what the state program's regulation looks like. If a state OSH program, North Carolina OSHA, Cal OSHA, others like that, have adopted a Fed OSHA regulation verbatim, then Fed OSHA's guidance about that interpretation are very important in the context we've been talking about. If you're defending against a citation in North Carolina about a record-keeping violation where North Carolina OSHA uses the identical language in their record-keeping standards, that interpretation is a powerful piece of evidence about what the rule means, and certainly in that defense we talked about before about having fair notice. That Fed OSHA has interpreted it this way, the rule is the same, there is no North Carolina OSHA interpretation that contradicts it. This is our fair notice about what the rule means. If the state agency has modified the rule or has entirely different rules, Cal OSHA, for example, has its own standards or has tweaked in important substantive ways comparable standards to Fed OSHA. The Fed OSHA interpretations are less valuable. They're worth something because, again, you're talking about your notice, what an employer's understanding of the law is, but they are much less influential when the standards are not identical. And similarly, if the state agency has issued its own interpretation and it is different than Fed OSHA's interpretation, that will supersede the Fed OSHA interpretation as long as it is at least as effective. If a state agency issues an interpretation that, and this doesn't really happen because Fed OSHA would not tolerate it, but and we've seen this happen, and Fed OSHA has pushed back, where a state agency says, you don't need to go this far, or you don't need to do this much, or the standard doesn't require it for these types of workplaces, that would not really be a lawful interpretation by the state agency because their authorization to conduct, to implement their own state program is conditioned on being at least as effective. So if you have an interpretation by a state that is less rigorous than the feds for a standard that is identical, you're on flimsy turf if you're trying to rely on that interpretation. But if a state agency's interpretation is more onerous, then that does supplant Fed OSHA's interpretation. And you would have to, abide, as long as it's not arbitrary or capricious, you would have to abide by the state agency's interpretation. There's a question here about statute of limitations to challenge guidance, or can you do so when facing an enforcement action potentially years later? There is a statute of limitations, I believe, and Kate is involved in these areas often more than I am, but a statute of limitations to bring an initial challenge about a new substantive interpretation if you are just bringing the challenge against the interpretation outside the context of a specific set of circumstances. But if you are issued a citation 4 years after an interpretation letter is issued, that letter has not been challenged before, and you believe that letter is unlawful, you have every right to challenge the letter in that context. It's the first time that it was a ripe issue for you, and so it would be a lawful challenge at that stage. But there are, generally speaking, if you are challenging a letter of interpretation or a guidance document or something like that as a standard and as having failed to go through the standard making process, I believe there are limits on bringing those types of challenges. But if it's in the context of your own citation, then you can do that when it arises. All right, I'm going to turn it over here to Kate to talk about background about variances.
All right. Well, so I want to start out with some humility. We OSHA lawyers in Washington, D.C., or lawyers in general, like to pretend like they, know everything about their subject matter. But I will share with you that I probably practiced in this area for a good decade before I knew that variances existed. It's a relatively not widely recognized portion of the Osha Act and our regulatory program. But I learned a long time ago about the existence of of the variance program that OSHA has that derives from the Osha Act. Osha Act Section 6, and those of you who are involved with standards and dealing with new standards in particular, you're very, very familiar with Section 6 of the Osha Act, which is the standard setting process and provision. But buried within Section 6, in a rarely, in my view, reviewed portion of the law, there is statutory authority for OSHA to grant variances, both variances that are temporary as well as permanent. Also, Section 16 of the Osha Act provides statutory authority to grant a defense variance. And we're not going to talk much about that, but there is a specific statutory authority that OSHA has to grant a variance from a regulation if there is a threat of serious impairment to national defense. That's probably all I'll say about that, because I want to focus on the broad variance program that allows for OSHA to grant permanent variances, temporary variances, and variances to OSHA's 1904 record-keeping provisions. I mentioned that this regulatory program is not very well known. It's within the OTCPA, which is part of the DTSEM. And if any of you on this phone call can tell me what those acronyms stand for, then you can take over this webinar, because these are offices within OSHA which, again, aren't kind of widely recognized. It's not inside the standards office, and the variance program is not run by the standards office, and it's not overseen by the enforcement office, the two big offices at OSHA. Rather, within the Directorate of the Technical Support and Emergency Management, there is an office called the Office of Technical Programs and Coordination Activities. And those offices run and oversee and administer variances. So this is the office that will review a variance application submitted by an employer or a trade association and grant or deny that application. The regulations that were developed pursuant to the statutory authority that I mentioned are found at 29 CFR 1905 generally, and then specifically for the record-keeping variance, you can find the regulation at 1904.38. So let me talk a little bit, kind of still staying on a high level, about what types of variances there are and what they do. Essentially, so there's a slide here that shows that there are these 5 types of variances that can be granted by OSHA. Let me just jump to number 3 and number 4 because we're not going to talk much about those, and then I'm going to spend most of the time talking about numbers 1 and numbers 2. Numbers 1 and 2. Experimental variances. Those are variances that the agency can grant to authorize an employer to basically test out and demonstrate the success or viability and effectiveness of a particular alternative to a workplace hazard control. So if you have developed a new process, a new way of managing hazards, and you think it is better than what the regulations would require, you can apply to OSHA, provide a lot of information. We'll talk about the details in a little bit as to what you have to prove and what information you have to submit to the agency. But you can request the agency to give you authority to engage in activity that would not be compliant under the standard, but would be done to test or demonstrate the viability of an alternative practice that you think will be, in fact, successful in meeting the standard. And these are short-term in duration, but they can be pretty helpful if granted, where someone has a new device, a new method, or a new control measure that it wants to test out to see if it will allow you to achieve the requirements that a standard has set. The national defense variance I mentioned very quickly. It's a very, very narrow defense under Section 16 of the Osha Act that is available for short-term, 6-month period without a public hearing. If it goes longer than 6 months, then there has to be a public hearing. And it can be re-upped essentially, I believe, once. And it is only to allow for an employer to deviate from a standard if there is a serious impairment to national defense at stake. All right, numbers 1 and 2, permanent and temporary variances. The Osha Act is short on language compared to many environmental and other statutes, but in this particular area, for a permanent variance, which I want to spend most of the time talking about, I think the statute itself lays out very clearly what a variance is and what the standard is to obtain one. So I just want to read you the language of the statute itself and then talk about, give some additional detail. The statute, and this is Section 6D of the standard as opposed to 6B, the standard setting provision, and this is for permanent variances. The statute says that the Secretary shall issue an order or rule for a variance if he determines on the record, after opportunity for an inspection, where appropriate, and a hearing, if requested, I'm adding a little language but not much, that the proponent, the employer or the trade association that's applying for the variance, has demonstrated by a preponderance of the evidence that the conditions, practices, means, methods, operations, or processes used or proposed to be used by the employer, and here's the key language, will provide employment and place of employment to his employees which are as safe and healthful as those which would prevail if he complied with the standard. And one more key piece to the statute says the rule or order, that is the variance, the grant of the variance, so issued shall prescribe the conditions the employer must maintain in order to have this variance. All right, so basically this is, an alternative to standard compliance. It does not apply to performance-based standards. It is to command and control standards that say that you have to do X, Y, and Z to, have a safe ladder or whatever. So that's what a permanent variance is. A temporary variance is very similar, but one key important limitation on a temporary variance is it is simply short-term relief from a new standard. All right, so when a new standard comes into effect, but you can demonstrate that, by a preponderance of the evidence with this process that's available to anyone who wants to challenge a variance application, if you can demonstrate that you can't achieve compliance by the effective date because of some limitation you have in the construction or alteration of something at your facility or access to personnel or equipment, you can apply for a short-term temporary variance. Now, one note on this temporary versus permanent. Under the permanent variance, you can also apply for a short-term permanent variance, and that is that would be a situation where you are doing some sort of project, some sort of construction. You can't meet the standard that would otherwise apply. There's no new standard at issue, but there's a new project at your facility. If you want to deviate from the otherwise applicable regulation or standard, you can apply for a permanent but short-term duration variance. Okay. The key to the variance program. First of all, let me just back up and say, as you can imagine, obtaining a variance to a particular regulation applicable to your facility would be of huge benefit under, a variety of circumstances. But OSHA, as we'll talk about a little later, is reluctant to grant variances and certainly will not grant variances unless the employer or the applicant, which could be a trade association on behalf of a set or class of employers, determines that you've met the legal threshold. And that was the key language that I pointed out in Section 6, which is that you have demonstrated that you will put in place some alternative that will be as safe or as helpful as the regulations that otherwise would apply. A couple of additional key points. Variances are binding on an employer, or available, I should say, to an employer until they expire. Permanent variances will not have a limitation, or if they do, it will be laid out very clearly. So you may have temporal limitation, as I mentioned, these short-term duration permanent variances. That will be very clear in the document that OSHA issues by the way, there's a lot of process associated with this notice and comment in the Federal Register. The granting of the variance will be in the Federal Register, and it will state any temporal limitation. The scope of coverage, unlike what Eric was explaining about letters of interpretation, the scope of coverage for a variance is limited to the applicant. Now, the applicant can be either a single employer, a group of like-minded employers, or a trade association on behalf of a listed number of applicants. But for instance, and this is important to understand, a trade association cannot, for instance, apply, on behalf of the industry for a particular variance without specifically, it can, but it won't be meaningful because the variance, if granted, will apply only to those employers that are listed in the application and only to those facilities that are identified in the application. State OSH programs. Okay, so what do you do when you're in a state program, a state-approved program? If the facility for which you would like to obtain the variance is only in that state, then you obviously apply to the state OSH program. However, if you are an employer with multiple facilities that are across state lines and you would like a variance for, those facilities, including a facility that is in a federal state as well as a state plan state, you have a choice to make. You can apply to both those agencies, both the, say, Indiana state plan as well as the federal agency to cover those facilities that are outside Indiana and in federal states. But you can also apply singularly in a consolidated application to federal OSHA. If for instance, if you think your chances of obtaining a variance are more favorable in federal OSHA, federal OSHA will coordinate with the state program, and the state program will have some rights under the process, but there is a mechanism that allows for the consolidation of this under one application to federal OSHA. Okay, We're going to switch back now. I've given you a little background on variances. We're going to switch back to talking about letters of interpretation and the process for obtaining those. And then we're going to talk on a higher level about, strategy, opportunities to help your facilities have a more workable approach to, doing whatever they do under these variances and letters of interpretation.
All right, so a little bit about processes, strategies, and pitfalls. We're going to talk about that for both, interpretation letters and variances. I'm going to start off the discussion about the processes for how you obtain a letter of interpretation, and there is both sort of the basic level how you do it, and the way that we recommend you do it from a strategic standpoint. The letter of interpretation process is not formal, unlike variances, which Kate will talk about. Literally, all that is required is a written request to OSHA's Directorate of Enforcement Programs. And that is ordinarily a letter, but it can be an email, it can be any form of writing, requesting an interpretation of some standard, application of some set of facts to a standard, or some enforcement policy of the agency. And they will respond to that and issue an interpretation letter. That is, at a high level, all that is required in the process. However, to avoid a negative or harmful response, there is a strategic approach that you can employ to getting an interpretation letter. And that strategic approach is one that involves careful planning, engagement with the agency at an early stage, and executing a relationship-based strategy. So the first thing you do is you identify what subject matter about which you want an interpretation, and primarily what interpretation you want. The idea is not just to get an answer, it's to get the answer that you believe is the appropriate answer based on your reading of the standard and how it applies to your business. So you identify your own industry experts, your own legal experts, you do an analysis about the way that this standard ought to be interpreted. Then you identify within OSHA the appropriate subject matter expert. Who is it at OSHA who is responsible for this issue? And you engage with that person. And the first thing you do, or the first thing that we recommend that you do, is you essentially negotiate an informal agreement that we have an issue we want to talk about with you, and we want an agreement with you that we can talk about this candidly without a letter being issued, a letter from OSHA being issued, unless we decide that that is what we want. So we want to hear, essentially, at least in an informal way, what your answer is going to be before we actually request an interpretation letter. And typically, the agency will agree to do that. They'll agree to talk with you, to get a high-level review from you about the issue, and to give you an early read about what the answer is likely to be, or what additional information they might want, or what additional factors, what additional elements you might need to introduce to get the answer that you think is the appropriate answer. Then you thoroughly vet the issue. You do this with the agency, with that point person, and you flesh out, the reasons why you think an interpretation ought to be a certain way, describing the facts and the factors and how, what administrative and engineering controls are in place, what background context is applicable, regulatory history, other interpretations, case law, perhaps technical factors from a technical expert's work that you've done in a lab, or otherwise testing the circumstances and advocating to the agency for a particular outcome. So often we see letters that are, sent in to the agency with no idea how they might answer, and without providing much context or background or, advocacy to the agency, and you just get what you're going to get, right? There's an old adage for lawyers, you never ask the question that you don't know the answer to. That's what this is about. It's engaging with the agency, not only finding out what their answer would be, but advocating for a particular answer and finding out from them what more would they need. Would you need additional testing? Would you need, one more engineering control? What would it take to get the answer to be what we would like for the answer to be? And when you get to that point, if you can get from the agency confirmation that the answer will be the one that you are looking for, You get that buy-in from them, and then you draft the request, and you work with the agency as you're drafting the request. And one of the things we also like to do is draft a proposed response. And you give it to the agency based on our discussion, based on things you've told us, OSHA, in response to our discussions. We believe, excuse me, we believe this is what you are saying the interpretation is. So we've, taken the courtesy of putting it down in writing for you. You can throw it in the trash if you'd like, but it's a starting point. And that way, you're setting up the best possible circumstance for an answer that you like. It is, when you do it that way, and really whether you do it that way or not, interpretation letters is a long process. You see very often at the bottom of an interpretation letter or in the first sentence of an interpretation letter on OSHA's website, an apology by the agency for how long it's taken to get back to you. So just going in, understand that this is not a quick process, and it's elongated further if you do it, I think, doing it the right way by pre-planning, engaging, advocating, and then drafting. It can take months, sometimes over a year, to get to that point where the interpretation letter is issued back to the employer or the law firm or the trade group who's requested it. I've seen, employers have come to me and said, I am confident that OSHA's got this wrong in this citation that they've issued to me. Let's go pursue an interpretation letter. Then we can use the interpretation letter in the challenge of the citation. I think it is unlikely, based on the way this process goes, that you'd ever get an answer timely enough that it can be used in a specific enforcement action that's already begun. The other thing that's sort of interesting about this is we see typically about 4 to 6 more months pass even after the requester gets the response from OSHA. We have an official formal letter of interpretation from OSHA in our hands, but it doesn't go up on OSHA's website for another half a year. You can still use the interpretation. You can still introduce it as evidence in hearings. You can use it in the context of an inspection or whatever reason you need to use it, but it won't be publicly known. It won't be published on OSHA's website for some time, even further after that. So now we'll talk a little bit about the process to obtain a variance, and then we'll get into the legal pitfalls for both.
Okay, so the process for obtaining a variance is a much, a much more public process, and there's more process around it, if you will. As Eric mentioned, letters of interpretation, from our perspective, are things that you work sort of behind the scenes, not publicly with OSHA. You talk to the right staff, you figure out what their thinking is, you share your thinking. It's all very informal. The variance process is a more formal process, and it's more public. Timing. Okay, so we've got a slide here that says it takes approximately 1 year. That's what OSHA identifies as the timing. These things are rarely used, so it was difficult for me to put an actual timing on this, real life, what it really takes. But it is clear that the more complex the request, for let's say we're requesting, an employer's requesting an alternative ventilation system for a spray booth. That's fairly technical, and it is going to require OSHA to really look very carefully at the current requirements, at the alternative, and it actually could take much longer than a year. But but I think the agency does try to keep this, this year-long process is something it, tries to keep it to that amount of time. Whether it's successful always or not is somewhat unclear, and the more complex, obviously, the more unlikely. You know what I'm going to do? I'm going to switch to the next slide, then come back, because I want to sort of outline for you the process that you engage in when you apply for a variance, and then we'll talk about some of these other details. So the regulations themselves, if you look at Section 29 CFR 1905, you will see some regulatory provisions related to application for a variance and the process associated therewith. However, There is not an actual application in the regulations, but if you look on OSHA's website, the agency has developed what I think is pretty helpful guidance, very helpful guidance, in the form of checklists and actual applications. So you don't have to use these applications and checklists, but they're very helpful, and they provide good information on, what it is you have to supply to the agency in the form of the application. For instance, you have to supply the name of the applicant and the address that they're going to that this variance will cover and apply to. You have to identify specifically the standard from which you're seeking a variance, obviously. You have to identify the type of variance. Is this a 1904 record-keeping variance, or is this a variance for, my portable ladders? And you have to, and very, very importantly, have to identify, describe, detail, and support the alternative means of compliance. And this, to my mind, is the absolute critical part of the application. As I mentioned, you have to list all the sites that will be covered by the variance. You also have to certify that you have informed the employees who would be affected by this about the method specified in the application, the alternative method. We added on here this pleading the alternative point, and what we want to point out here is, as you can imagine, the greatest risk or the biggest concern with employers applying for a variance is you're basically going to the agency and you're saying, we can't comply with this particular regulation, or we don't want to comply with this, or we have good reasons why we can't comply. We'd like to do this instead, and it's absolutely as safe as, in fact, it's more safe than what your regulations would require. Well, have you not just given the agency, an enforcement agency, notice that you're not in compliance with a particular regulation? And aren't employers going to be extremely reluctant to do that? Now, I will tell you from experience and from, in fact, it's set out on the OSHA website. I know many of you may think this is called comfort, but OSHA will not. The Variance Office, as I mentioned, the office within the Directorate of DSTEM, the Office of Technical Programs and Coordination Activities, those people who review, grant, and refuse to grant variances, those people are not the enforcement personnel. The agency, by practice and by policy, does not share this information with enforcement, with the Federal Enforcement Office. However, and importantly, as part of the application process, OSHA has the right to conduct a site assessment. And the site assessment is typically done by the area office in the area in which your facility is located. So you are, in fact, informing the area office that you're not in compliance with this particular regulation. We have not seen, and I do not believe, that the agency is using these variance applications to identify targets for enforcement, okay? However, I think we have to be cautious about this and careful. If OSHA is going to come on site, for instance, to do a variant site assessment, you need to make sure that all your ducks are in a row at your facility otherwise, because certainly any violation in site could, in fact, be, a citation could be, an enforcement action could be begun, and a citation could be ultimately issued. What we're talking about in terms of pleading in the alternative is, it may strategically be wise and prudent to, at the same time we are submitting, for instance, a variance application, to also be submitting a letter of interpretation to the folks in Washington, the enforcement office, saying, we think we're in compliance here, but we want to narrow down and get you guys to determine that our form of compliance, which is the alternative we're suggesting in the variance application, is in fact compliant. It doesn't cover you wholly. Could the variance application be used as an admission? Theoretically, possibly. Have we covered ourselves a little bit by submitting this letter of interpretation request saying we think this is compliant? Perhaps so. So anyway, I guess the bottom line is it's a very tricky process, and you shouldn't just willy-nilly go out and submit a variance application. It should be carefully thought through, and we should, just make sure that everything is covered. You're protected legally. Okay. One thing that I'm going to mention, and then I'm going to turn it back over to Eric, is this interim order idea. OSHA provides for an interim order to be requested and granted simultaneously with the variance application. That is a request that you make as an employer to say, let me comply with this alternative means while you guys are reviewing my variance application. That also insulates you. That insulates you fully, if granted, from a noncompliance event or enforcement action. So we can talk more about that, but I just wanted to make that clear.
All right. So I think Kate covered legal pitfalls associated with the variance process. I've got a slide here about legal pitfalls associated with the interpretation letter process, and they're very similar. The idea in the variance process that you are admitting that you have a non-compliant situation, sharing a lot of sensitive information with OSHA and inviting them in to see your operations, or whether physically or just to look under the hood. You are here in the letter of interpretation context doing the same thing, essentially. You're sharing a lot of sensitive information with OSHA. Often we do this, again, client anonymous, which you cannot do in the variance context. If you've got counsel like us sort of leading that advocacy process with OSHA, then you are not revealing specifics about a company, but you might be revealing specifics about an industry or a standard industry practice. And that risks, an invitation for inspections, risks an invitation for enforcement, perhaps even on a broad level to the entire industry. And then the other big pitfall is if you don't do it right, you could be inviting a flawed interpretation from OSHA. If you are not advocating and you're not doing the pre-planning that's necessary, you may get someone at OSHA without expertise and without giving it enough thought put out an interpretation that is harmful to you or to the entire industry. And here's an example where we saw this happen back in 2009 in the grain industry. An insurance representative, a loss control rep for an insurance company, requested an interpretation about working inside of grain bins with an energized sweep auger. But they basically just said, hey, your standard says you can't be in there with equipment that can cause harm. What about sweep augers? And, without really advocating for the right outcome here, OSHA, without much experience in the grain industry or in understanding what a sweep auger is and how it operates and how it can be worked with safely, basically wrote a letter that says, okay, then you're right, that's a piece of equipment that you can't work around inside of a bin, and basically abandoned or abolished an age-old practice that is critical to work in the grain industry. And immediately what followed was local and regional emphasis programs in the grain industry and a slew of willful violations issued to grain operators across the Corn Belt. It took a series of inspections, challenges to citations, and some engagement with the OSHA National Office and some subject matter experts within OSHA who are knowledgeable about grain operations to get OSHA to reverse that interpretation letter, put out a new enforcement memo changing that interpretation, and our firm worked closely on that to get that interpretation reversed, but showing that sort of if the process isn't followed and done correctly the first time, you create here a 4-year period of flux, uncertainty, and lots of willful violations that could have been avoided. Kate talked about the pitfalls already of the variance process, and I think in conjunction with the process itself. But here it is. I'm not sure she did talk, though, about how historically very low the likelihood of success is. So I'll let her talk about that here in the context of this interesting slide.
Right. Well, so, we talked about this issue, the risk issue. But in addition to that, at least historically, we've looked at this. In fact, I've submitted a couple of variance applications. we know from past practice and looking at the OSHA's analysis of the request for variances that they really have not been granted very much. I want to talk in a minute about the future, but historically anyway, if you look on, OSHA's got a good website on this, and they collect all the variance applications and tell you, whether they were granted or denied, and give a brief description. It's actually really interesting, and so we pulled this from their website, and it looks to us like over the last 20 years, approximately 240 variances have been denied and or withdrawn. Now, that tells you two important things. One, I wasn't so, out of it when I went 10 years without even knowing of the variance program because, 240 over 20 years, right? That's not many. There are, I don't know how many million employees there are denied or withdrawn, right? Very, very good point. So I don't know how many employers are out there, probably something I should know, but point is 240 is not much. Now, that number does reflect those that were denied and or they were withdrawn. And withdrawn would suggest, at least we looked into this a little bit, and looks like where an employer thinks they may not obtain a variance based on with the agency, the employer at times has withdrawn the request, so it doesn't get a denial. OSHA from time to time does issue, though, these variances. We found that there were 12 total variances that are currently in effect, 5 of which were granted during the Obama administration. And we've listed here those variances. You'll see that there's only one that was issued to Nucor in general industry, one was in maritime, and 3 are in construction. And I think a couple of these in construction are identical. Different employers, different requests, but same process. And that's something important to note. If you see in analyzing the variances that have been granted something like what you would like to do, I mean, that it's not a shoo-in necessarily, but it sure is a sign that OSHA is receptive to this sort of condition or practice or alternative to compliance with a particular regulation. So that's just sort of another caution about using the variance program. You really got it, and the key, absolute key, is the as safe as stuff and the conditions. OSHA is much, much, much more likely to grant a variance if you are willing to accept the conditions that they lay out for the variance.
All right, so we've talked a little bit about pitfalls and some strategies. We have not talked about why. Why is this something that you would want to do? And then also, why now? Why did we think this was a really good subject to include in our webinar series at this point in history? Why? There's a few reasons why you'd want to do this. Clarity is an important one. Letters of interpretation are, like we said, the agency's formal interpretation, the agency's official position that you can rely on, that you can introduce as evidence, that you can build programs and build procedures and practices around. It is guidance on how to comply. And it's definitive. The language of the standard may not always be clear. How it applies in your industry or how it applies to your circumstances, a letter of interpretation can be more specific and more granular and give you clarity about how to operate safely. Letters of interpretations and variances have a great opportunity to relieve operational burden. If you think there is a work practice or a type of equipment or a procedure or something that you believe is compliant but you don't know, or you know it's not compliant and you think it's just as safe, you can pursue these regulatory strategies to get relief from what is an otherwise onerous practice. Right now, OSHA is enforcing the law this way. We think it's wrong. We think we can demonstrate why it's wrong. And if we can get a letter of interpretation that says so, then we don't have to do these 5 extra steps or introduce these 3 extra engineering controls that aren't necessary to comply with the law. That gives you operational, relief. Similarly, and more directly for a variance, you're saying here's a way that we think is just as safe but doesn't technically comply, but we have to do it this way, or it's more efficient to do it this way. You get the variance, you get that relief. I've seen instances where employers do things a certain way that they believe this is what the law requires, but it is burdensome and it's onerous, but their peers in the industry aren't doing it. They're essentially cutting corners. I've seen employers use the letter of interpretation process to even the playing field, so to speak, that my competitors aren't doing this because the law is not as clear, but it seems to me that this is what the law requires. Go out and get an interpretation letter so that everybody in the industry knows that that's what's required to even the playing field. Similarly, doing something to gain a competitive advantage, you see less often because in the safety universe, people generally share. But if you have some proprietary technology or some proprietary process or some efficient process, or you can do something more efficiently, you might want an interpretation letter out there that makes things more burdensome from your competitors because you've developed some way to do that same thing, compliant, in a more efficient way. So you can use a letter of interpretation to make your competitors meet a certain regulatory practice that you're able to do more efficiently could create some competitive advantage for you. These others are lumped together here. The concept is reconciling conflicts, and this is where most often requests for interpretation, or we're approached by clients about pursuing interpretation letters, is where there is one pocket of the country where a particular area director or a particular area office has what we would consider to be a distorted view of what the law requires, and it's not consistent with what other area offices and other regions are doing. And so you can use the letter of interpretation process to sort of go over the head of that area office, to go to the national office and say, we need a consistent application of this standard around the country. Isn't this what the law requires? And then when you get that letter, the area director or area office or region that wants to do something differently is now bound to follow what the national office is saying the law is. And you can use the interpretation letter to get those one-off regulators in line with the rest of the country. And often, we found that the national office is easier to deal with than an area office, and for a variety of different reasons. One might be the area office doesn't really have authority to buck the system or to change things in a significant way. Those types of big changes, different interpretations at a broad level can only be done by the national office. So trying to do it one at a time in a citation process or inspection process with the area office is not efficient and probably not going to be very successful. So there's a need in those circumstances to go over the area office, go to the national office, and maybe you just have a more receptive audience for a variety of reasons. For example, now we're going to talk about why you have, Republican-appointed senior leadership at Osha, where area directors and folks out in the area and the regions are career folks who may have a different view of employers than perhaps some folks in the national office might have. And then, letters of interpretation and variances both will provide for you or can provide for you a legal defense in the event of an enforcement action. That's a reason why you might pursue one, because you anticipate some inspector, some compliance officer, some area director might take a different view of what the law requires. In anticipation of that, you go and get an interpretation letter, get some clarity around what the law requires, and so you can use it to defend a future enforcement action if it arises. Why now is, I think you all probably have a pretty good sense of why. It's a new administration. It is a new world order. And here, as a regulatory defense lawyer, I, pop awake at night in a cold sweat thinking about Steve Bannon giving his speech at CPAC and saying, it's all about the deconstruction of the regulatory state, the deconstruction of the administrative state. Look at the appointees that the Trump administration is making. They're selected for a reason, and that's deconstruction, right? That's why you take, former governor of Texas who campaigned for president on eliminating the energy department, now is the Secretary of Energy. It's why you nominate people to run the Environmental Protection Agency who have filed more lawsuits against the EPA than any other former state attorney general in history. It's about deregulation, deconstruction of the administrative state. So now is a sort of unique environment, perhaps a more receptive audience at agencies like Osha to employers' views of how regulations ought to be interpreted, and perhaps more receptive also to variances, to lending a little bit more credibility to an employer's view, to an employer's studies, to an employer's science about why some action they may take is just as safe as what the regulation requires. Perhaps more benefit of the doubt to the employer, so to speak. So this is what we've seen just in the first few months of the Trump administration that does suggest that there is a new approach to employers, a new approach by the Department of Labor in how they would manage some of these issues and questions perhaps more favorably for employers. We've seen a series of executive orders all about cutting government regulations, making things less burdensome for employers. The previous memo, a temporary delay in the effective dates of all new regulations, again, relieving the burden on employers in meaningful ways. The Congressional Review Act was used much more substantially than it has ever in the past to repeal Obama-era midnight rules, and many of those were OSHA-related, Department of Labor-related, but in a broad sense, just peeling back burdens on employers. That's the signal we're getting from this administration. They eliminated the FAR, Department of Labor blacklisting rule, the Volks record-keeping statute of limitations rule. They took a hard look at getting rid of the EPA RMP rule. It didn't happen through Congressional Review Act. It may happen through rulemaking. But again, the signals from the agency and from the administration, I should say really the administration, not so much the agency, have been about relieving burdens on employers, which means they may be more receptive to new interpretations and variances that relieve burdens on employers. They're not defending legal challenges to some Obama-era rules. Trump's blueprint budget, took major cuts at the Department of Labor budget, and there is already, we're seeing signals of a shift in enforcement philosophy, really a heavier focus on compliance assistance, working to solidify the VPP role, increasing the budget for things like that where there are cuts otherwise. So that's why now would be a good time to really look at and pursue these types of regulatory strategies.
And just as a follow-up to what Eric is talking about in terms of the sort of, I guess you'd say, pro-business outlook and environment at the agency that will likely take hold as the new appointees, become, sitting in their offices over on the second floor of the Department of Labor at OSHA. The other thing to keep in mind is that the current process, the rulemaking process, where a company wants to have a rule in place, you're not trying to skirt the regulations, you're trying to set a rule that is effective. The rulemaking process is terribly burdensome, awfully cumbersome, and I think everyone at OSHA would admit sort of a failed process. You can't rely on that process to get, at least right now, it doesn't seem like it's easy to rely on that process to get a rule in place or a standard in place. So I think that's yet another reason to think about the use of these alternative, statutorily authorized mechanisms that are available to all employers or all stakeholders. The other thing that we want to point out is, as Eric was referencing, under the Obama administration, that administration already has relied pretty heavily on these letters of interpretation and enforcement memoranda to, fill in the gaps, if you will, between regulations, in part because of what I just said. It's impossible to get regulations promulgated. So they, were sort of forced to go that route. And they have a lot of discretion that you don't have when you have to go through the formal notice and comment process of developing regulations. And also mortgage bankers came down. Now there is the ag retailers purported limitation, but mortgage bankers basically provides, it upends the longstanding principle that you can't change rules without notice and comment. So there's much more discretion the agency has under mortgage bankers, again, set aside the caveat of ag retailers, about use of these discretionary tools. And we've listed on the slide, the various examples of the Obama administration's use of these tools to move the law in the direction that they'd like to see it, including the union walk-around rights. The FAR rule, that's a perfect example of what we're talking about, where there were, the actual regulation itself that was issued by the council, the FAR council, was, a short, I don't know how many pages in the Federal Register, but not many compared to the massive guidance document that also appeared in the Federal Register simultaneously, issued by the Department of Labor. So it's basically a few words of law and tremendous amount of guidance that basically shows you what the law is. Also with e-record keeping, anti-retaliation language. If any of you followed that, the language of the regulation itself was sparse and, vague, but the guidance that the agency issued, which was much more specific, no comment on right or wrong, just more specific and clear than was issued than the regulation itself. The Grain Industry Sweep Auger Enforcement Memo, as I think Eric mentioned, and obviously the huge retail exemption change with the PSM letter of interpretation that resulted in ag retailers. Anyway, those are just some examples of how the past administration used these tools. And I, as a lawyer who's worked in this field for many years and acknowledged early on that I didn't even know what variances were, I will tell you that, it's a statutory tool that Congress gave the agency to deviate from onerous or ineffective or, regulations generally, where an employer can come up with a better way to ensure the health and safety of its employees. I think that the new administration ought to very seriously consider sort of revitalizing the variance program and really use it as an effective tool sanctioned by Congress to avoid the problems that the agency faces with rulemaking and to ensure the health and safety of employees, where employers are in good faith, have in fact developed conditions, practices, alternatives that in fact protect employees. They're the experts sometimes, much more even than OSHA. So why not let their development of systems to protect employees be what guides and defines what they have to do at their work site.
So we've held you for a real long time. I'm not going to keep you much longer. I have just one final slide here, substantively, and we don't really need to go into any detail on this. This was just as my team here at Conn Maciel Carey sat around and brainstormed about areas where there might be opportunities to pursue new interpretations as the Trump appointees get in place at OSHA, and this sort of idea of a more receptive audience we think will come into place. An opportunity to pursue, we think, more appropriate interpretations or reinterpretations of some other, recent problematic interpretations. And this is sort of your menu of possible options. If you see something here that affects your business that you'd like to talk about in more detail, let us know. I'll highlight a couple of interesting ones. One is the union walk-around rule, where during the Obama administration, an interpretation letter was issued that said employees may select as an employee representative during an OSHA inspection a union representative from a union that does not have a collective bargaining agreement in place at that workplace. In other words, the union does not formally represent those employees. It does not have a relationship with that workplace. Employees can still select a representative from that union to be the walk-around representative during an OSHA inspection. That letter seemed to be plainly contrary to the regulatory language that says an employee inspection representative shall be an employee of the employer, except in extraordinary circumstances where there is some special expertise that is required of a third party to make the inspection productive. And often when this letter was being used to bring outside union representatives into inspections, it was a union organizer, perhaps an industrial hygienist at best. But those folks are not folks that, it seems to me, consistent with the rule, bring some unique specialty expertise that are necessary for an inspector to effectively inspect a workplace. There are many, many, many industrial hygienists within OSHA who have the same knowledge and skill as some third-party union industrial hygienist, and certainly a union organizer does not have any special skill that would be necessary for an effective safety and health inspection. So that letter was issued. It has since been rescinded in the very, very first days of the new administration. But rescinding it does not necessarily create the clarity that we've all been looking for or that a letter of interpretation can provide. What I think is needed is a new letter that says precisely what the standard what the regulation allows in terms of employee representatives and what those special skill set is that a third party needs to bring to the table to be authorized to participate in inspections. So that's one area. A lot of other sort of inspection or enforcement policies that I think are ripe for a good letter of interpretation or some new guidance. What is a legal successor from an OSHA standpoint? There are old interpretation letters about that. That interpretation has expanded and grown as OSHA has tried to find and cite more repeat violations. I think there's an opportunity to redefine and correctly define what is a legal successor from an OSHA standpoint. I think we're seeing the beginnings of some efforts to abuse the egregious per instance policy, to use it in circumstances where it does not fit, is not lawful. Guidance or interpretations on that issue I think would be appropriate. There's any number of issues under the process safety management standard where interpretations would be helpful. We've seen over the last several years OSHA expanding the definitions of coverage, the definitions and scope of mechanical integrity requirements, what practices require standard operating procedures. There's opportunities there to negotiate with OSHA over an appropriate interpretation and get some good clarity on the books, either in advance of amendments to the PSM standard or in lieu of amendments to the PSM standard. Record keeping is an area where there's lots of opportunities around the meaning of and how you can address minor musculoskeletal disorders and whether exercise and stretching is appropriate or make something a recordable injury. A really, really big one is the anti-retaliation elements of the electronic record-keeping rule. Now, there's efforts underway that signal that this rule may be going away. If that happens, then an interpretation would not be necessary. But as it stands, the rule itself, the regulation that introduced this sort of anti-drug testing, anti-safety incentive policies, the regulation doesn't say anything about drug testing or safety incentives. It just talks about programs that might discourage reporting. It is guidance that OSHA issued under the Obama administration that made this regulation relate to post-injury drug testing and safety incentive programs. Well, new interpretations or new guidance could push back on that unless or until the rule is otherwise addressed. And then there's a host of other just general industry safety issues that I think there's opportunities for better clarification or for peeling back what have been efforts either through citations or past interpretations to pervert the original meaning of standards or to otherwise move in a direction that is unnecessarily burdensome on employers. And we would love the opportunity to work with trade groups and employers to fix some of those problem areas. That is the discussion that we had in mind for interpretations and variances. I'd encourage you all to continue to join us for these monthly webinars. Here's the schedule for what's coming up. You'll see in an email following this webinar some information about how to register for all of the rest of the events if you're interested in that. Also would encourage you to check out our blog, the OSHA Defense Report, www.oshadefensereport.com, and we'll address a couple of questions here before we turn off the recording. There's one question here not necessarily related to variances and interpretations, but it is an extremely timely and appropriate question. What's the status of the e-reporting rule, which is supposed to take effect July 1st? This is the other half of the electronic record-keeping rule. I talked about the anti-retaliation elements, but the major thrust of this new record-keeping rule was that employers of a certain size and in certain industries, are required to proactively submit certain injury and illness record-keeping data to OSHA, and the first deadline for that submission, which was going to be just 300A data for employers of 20 and up in certain industries, 250 and up across all industries. OSHA has announced on its website an indefinite delay of that reporting requirement. And OSHA was creating a database to receive that data so that you could submit it electronically to OSHA. They have not taken that database live. I understand they have finished building it, and in fact, I know that they have beta tested it with some significant employers and trade groups, and it was ready, technologically ready to go live, but was held back as we transitioned to the new administration so that the new administration could sort of wrap their head around this new rule and make decisions about whether they're going to continue to implement it, whether they need to make changes to it, or how they want to address it. And so, as we got, at this point, less than a month away from that deadline to submit the data for the first time, the database is still not live. OSHA announced on its website a delay of that July 1st date. They did not assign a new date to it. They did not say how long the delay would be. They did not say whether it would be permanent or if any changes would be made. They've not announced that they're reopening the rulemaking record to pursue formally changes to the rule. So right now all I can tell you is that you do not have an obligation to submit any data by July 1st. It has been delayed, and as of this moment there is still no website or database for which employers could submit that data even if they wanted to. So don't do it in hard copy. Don't do anything. Let's wait and see what direction the agency goes before we ever submit any data. One other really interesting question here about variances, and Kate and I actually talked about this issue before the webinar. If a company or a facility applies for and obtains a variance, or successful in obtaining a permanent variance, but then changes owners or changes companies, do those variances still apply to that facility? That's a slightly different question than we talked about. We talked about the scenario where you get the variance, but some change in your operation says we don't really need the variance anymore. We're just going to comply with what the standard requires. Can you be, dinged or penalized for not complying with your variance approach? And our answer was, if you're complying with the regulation, you're fine. If the variance allows you to do something different and you decline to do that, but what you are doing otherwise complies with the law, you're not going to be penalized for doing that. But this is a great question about a change in ownership. Does the variance carry over? I've got an instinct about that. I'll hear Kate's thought, and I'll share mine.
Yeah. Okay, hopefully they're the same.
We'll see.
Just to tidy up on that last point that Eric was just making, one of the things to do if you're in that situation where you have changed processes and now, the regulation is a better fit for your operation, you should notice the agency, the variance office, and have that have that variance taken off the books, just to tidy up. But in terms of enforcement issue, there would not be an issue with complying with the regulation. Similarly, on this situation, really good question. I don't think I know precisely, for sure, absolutely the answer, but my instinct is that this would be simply an administrative, issue. You'd want to, just to be safe, you'd want to notify the variance office, inform them of the change of ownership, and maybe submit a revised application under the name of the new owner. But, one thing we didn't talk much about because we were limited in terms of time is the process. Once the application for the variance is submitted, there's all this process. It goes in the agency goes into a little bit of a black box. The agency considers it. We would be engaged with the agency, attempting to, educate them, inform them. There's possibility of a site assessment, but ultimately then let's say the agency is inclined to grant the application, it is noticed in the Federal Register, and then there's a period for comment. Now, not many people are probably going to comment, but there is an opportunity for stakeholders to comment, and then it is finalized in the Federal Register as well. So the point is, if there's a new leader, a new owner, would you have to go through that elaborate process? I think the answer is no. I think we'd want to just talk to Mr. Robinson over in the Variance office. He runs the Variance office, and find out exactly what you do. But I think it's probably an administrative split. Do you think that's
Yeah,
right?
I mean, my view is it sort of depends on the nature of the change in ownership. If it is a change in ownership that is tantamount to a successorship circumstance, I think perhaps an administrative change would be necessary, and perhaps nothing is necessary.
Right.
If you're a true legal successor, you might not even need to go about that change. But it's probably the safest move would be to at least get the name changed on the variance, which would not involve, my expectation would be not involve going through the whole process again. But if you are a legal successor, meaning there is substantial continuity of operations, same employees in the same location, substantially same set of employees in the same location, performing the same work activities for the same general customers in the same industry, OSHA is going to treat you from an enforcement standpoint as the same employer. You ought to at least therefore benefit from being treated as the same employer from the variance standpoint. So I think if you are operating as a successor, then there is a very good chance that you can just rely on the existing variance without taking any steps, but the safer measure would be to try and get it administratively changed.
Yeah, but that would just be a minor thing. It would be a paperwork thing. We don't see it as a substantive challenge.
So I am delighted that you all joined us today. Sorry we kept you a little long. We were just having so much fun. I hope you were too. And we'll look out for having you join us again next time. And thanks again for your interest in this webinar series. If you have any questions that we didn't get to or that you think about at another time, please don't hesitate to reach out. We're always happy to talk about safety and health regulatory issues. We're big OSHA nerds, so always happy to talk. Thanks again.